Hi guys, it's Kathy. I hope you're still doing well. Alright guys, thanks for coming out last night. I really appreciate it. And now we're back to our regularly scheduled program. And we have, remember the Sov Cit that went in front of Judge Fish? He sent him to jail for one night. And he said, okay, we're going to try this tomorrow. Well, this is tomorrow. We're going to watch tomorrow. And then we're just going to stay with Judge Fish the whole stream. We're going to watch April 1st and April 2nd. And that's what we're going to do. He doesn't have the sound on yet. Hold on, give him a second. Or everything is just broken. I'm gonna lose my mind. I'm gonna bump it forward a little bit. I thought I cut it right when he started.
In return.
And I didn't. There we go.
Trial, a lawyer will give an opening statement and make a closing argument, and they're capable of doing that very artfully. Have you ever had experience speaking in front of people?
I'm doing it right now.
Have you ever had experience speaking in front of a large group of people?
Yes, I have.
Okay, tell me about that.
I can't remember.
Okay,
I don't know how to articulate it is what I actually mean.
well, you would articulate it by telling me what experience you have.
I've been in front of people where I've spoke to a group of people before.
How many people do you think were in that group?
At least 25 plus.
Okay, and how many, how
It's a
often?
presentation.
How often have you had the opportunity to do that?
More than a handful of times.
How many is more than a handful? 6?
I have no idea. I cannot give you, that would be lying.
Okay. The other thing that a lawyer would do in a trial is help the court prepare jury instructions and select a jury. You understand how to select a jury?
Yes,
What would you do in that circumstance?
I would cross-examine them.
You would. Lawyers have the training, knowledge, and skill at properly preserving the record of a case for appeal. Have you ever been involved in an appeal?
No,
An attorney can also evaluate the strengths and weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement, which might result in a dismissal of some of the charges or a recommendation of a favorable sentence in return for your plea of guilty. This is an important part, and I would ask you to take note that you will, if you decide to not have an attorney, you'll not receive any special treatment with your defense. You'll have to follow all the same rules and procedures in your case as an attorney would have to. The state will have a competent attorney, and they'll have that advantage that an attorney represents for them. If you decide to represent yourself and the result turns out badly, you need to know that you will not be able to complain that you were ineffective as your own attorney in your defense. As I told you, you have a right to decide against having an attorney, but you must be aware that deciding not to have an attorney can turn out to be a very bad decision. Experienced lawyers almost would always decide to be represented by another lawyer in a criminal case. There are some of the things that you should consider before you appear at trial without an attorney, and I want to go through a little bit more now. Tell me more about your skills and knowledge that you have that you believe would be helpful in representing yourself.
where do you want me to begin? Ask me a question and I'll answer it.
I ask you a question, sir. What skills or knowledge do you have that would be helpful to you in this regard?
I'm able to learn quickly, and I know I can represent myself.
What's your college work? And you mentioned you had some college work.
Personal training as a personal trainer.
Okay, like in a gym or something like that? When you work in the gym, do you work with people, interact with people?
Yes, all the time. I did.
Do you still have that job?
No.
What other work have you done? What other career have you had?
I worked at a pharmaceutical company where I led teams. I developed drugs, and I was promoted multiple times.
See, now if JK was in chat, JK would say, translation, drug dealer.
As team leader to a supervisor.
To what degree did you lead people?
We led multi-million-dollar studies that had my name attached to those, to where I had a lot of responsibility and I had to learn fast and move fast.
Have you ever
And
studied criminal? Go ahead.
Well, I never was in the pharmaceutical company, so I learned fast, and I only had that job for 3 years, and I was able to propel myself that quickly with the little knowledge I had.
Have you ever studied criminal law?
I'm studying it now.
Have you ever studied criminal law previous to now?
No.
Have you ever had previous experience in the criminal justice system?
Yes.
What's the experience you've had in the criminal justice system?
When I was dealing with previous cases in the early 2000s,
Okay, tell me more about that.
I submitted to whatever the court told me to do. What do you mean?
What type of case were you involved with?
Drug cases.
Okay, and is that a case or cases where you were charged with crimes?
Yes.
And are those cases where you came to court?
What's that word mean? Caped, where they represented me?
I said came.
Oh, came, sorry.
Came to court? Did you have to come to court for those?
Yes, I did.
And did you have an attorney?
Yes, at that time.
Okay. Did you go to trial?
He's doing much better today, guys. He's starting off much better.
No.
So what was the result of the case?
I pled guilty to those charges.
Okay. Is that the limit of your experience in a criminal case?
Yes.
All right. You believe you're able to read a lot of information and
Yes.
adjust a lot of information?
Yes.
What about your writing
His personal trainer college taught him that, Judge.
ability?
Yes.
Tell me more about your ability to write.
I write good.
I wrote up all those notices. You didn't read them?
You wrote some documents and
Yes.
filed those with the court on 2 separate occasions.
Yes.
I struck both of those filings from the record because.
Yes. But that's the degree that I'm on.
Okay, so how did you compose those?
I
ChatGPT.
wrote them.
And what did you use as reference?
Equitable law.
Okay, you understand this is not a court of equity?
You're telling me that that all courts are not with equity? No court in Indiana is equitable?
This is not an equitable proceeding here. Absolutely not. This is a proceeding at law.
Okay. Well, I represent myself under equitable law.
Well, we make
I write more or gooder.
I think, fine distinction in Indiana between what are equitable cases and what are cases at law. And this one most assuredly is a case at law. You're entitled to a jury trial. You understand that in an equitable case, you're not entitled to a jury trial? You understand that?
Yep.
You do?
You're telling me now.
Okay.
I'm learning as I go.
Okay. Anyway, so you, along that same vein, had filed some documents with the court. In those documents, you attempted to distinguish between your physical self and a capitalized corporate version of your name, not even your legal name. Do you understand that the court doesn't recognize that distinction?
No, I do not.
Okay. You understand that if you represent yourself, you'll be proceeding as the single legal entity named in the charging information, specifically Michael Corleone Allegretti.
That's not my name.
You understand that the court won't entertain any arguments to the
I feel like he stole Michael Corleone from someone else. I just feel that way.
contrary.
If that's what you're telling me.
Okay?
Okay, listen. If you don't understand what I just said, do not tell me because you'll break my heart in a billion pieces, okay? Just don't even say anything.
Is that a yes or a no?
I understand that.
No. What I asked was whether or not you are aware that the court will not entertain arguments to the contrary. Your name is Michael Corleone Allegretti. That is your legal name.
That's not my legal name. I changed it.
Do you have documentation that you
Yes,
changed
I
your
do.
name? Please don't cut me
I'm
off.
sorry.
Where did you get that documentation?
In Michigan.
In the state of Michigan?
Yes.
You have a court order that changes your legal name?
Yes, I do.
Where's that documentation?
In my files. I had it in my possession yesterday.
Okay. Well, in this order today, will order you to provide the change of name
I will.
order from the state of Michigan to the court
I have no problem.
within, say, 10 days.
I can do it today.
Judge
And
Fish
then-
is going to give him an offer he cannot refuse, or he can confuse. I can confuse it.
Well, I'm going to give you 10 days.
Okay, thank you.
And then have you not changed your driver's license?
Not yet. I'm still in the process of doing everything.
When did you have the hearing that resulted in the name change?
I put it on my documents when I
7
gave you
years
the
ago.
notice of intent. I put it on my documents then. Do you still have the copies?
How recently was it?
I don't remember the exact date.
Did you have to go to court in Michigan for it?
Yes.
You don't remember when it was?
I don't know the exact date, no.
Were these charges
I gave you all the documents, sir.
were these charges already filed at that time?
Yes.
Okay. You also, in those filings, suggested you're making a special appearance or that you do not consent to this court's jurisdiction. You understand that in a criminal proceeding, your personal consent to the court's jurisdiction is not legally required.
Say it again.
Do you understand that in a criminal proceeding in Indiana, your personal consent to the court's jurisdiction is not legally required?
No, I don't understand that.
Okay. Do you understand that the state of Indiana has jurisdiction over the charges filed against you, and this case will move forward regardless of whether you agree with that jurisdiction?
I don't understand that either.
Okay. You seem to be clever enough to understand these things. I asked you earlier whether or not you're suffering from a mental health condition. I predict that at a certain point, if you continue to suggest you don't understand simple terms, that your attorney will suggest to me that I need to have you evaluated for competency. Do you understand that that's a possibility here?
Nobody's speaking for me. He's not my legal representation.
For the record, I called competency last time, way early.
Oh, he is. Do you believe that you are incompetent and incapable of proceeding on because of a mental incapacity?
No.
Do you believe you understand the players in the courtroom?
What players?
Do you believe you know what I do as the judge?
I believe you're an actor.
Okay, sir. The other thing that you put in the record, you attempted to apply concepts like suretyship, subrogation, demands for accounting, and different things like that in these criminal charges. And as recently as a few minutes ago, insisted that you're dealing with an equitable case here. You understand that the Uniform Commercial Code, civil contract law, and commercial equity have absolutely no application in this criminal prosecution?
I'm just here to settle the matter and put my stuff on record that you already struck. How come we're going over it if you already struck it?
Sir, it's an important part of the Ferretta determination. I can't allow you to represent yourself if you can't answer affirmatively to these questions. And you've already not answered affirmatively to 2 out of the 4 that I have here that I want to make sure that we go through. You understand that?
No.
Okay. Well, what I said was, and I just want to make sure our record's clear, the UCC, civil contract law, commercial equity have no application in this criminal prosecution. And you understand that the only rules that apply here are the Indiana Rules of Criminal Procedure, the Indiana Trial Rules as they're brought into those criminal procedure rules, Indiana Rules of Evidence, and substantive criminal laws of the state, along with various other administrative rules that we have to abide by, including our jury rules. You understand those are the only rules that apply in this case?
I understand now.
You do understand?
I understand what you just said.
Okay. And then I want to make sure you're clear. The United States Supreme Court has made it clear that the right of self-representation is not a license to abuse the dignity of the courtroom, nor is it a license to ignore the actual rules of procedure. Do you recognize that?
Yes.
You understand that if you are allowed to represent yourself, you'll be held, as I mentioned, to the exact same standards as a lawyer, as a licensed attorney.
Am I ready to talk? I'm sorry.
I'm just waiting on your response.
Oh, yeah. Yes.
And you understand that I will not permit you to waste the court's time or the jury's time by raising the theories that you've raised thus far, commercial law defenses, or challenging, say, the capitalization of your name, for example.
Monica, thank you for the cheers. Thank you.
You want me to answer?
It was a question. You
Yes.
understand that?
Yeah.
And you understand that if you attempt to use your self-representation to file frivolous documents, disrupt proceedings, or refuse to follow rulings on issues, I'll find that you forfeited your right to represent yourself and will appoint counsel to take over your defense.
Are you going to give me examples of frivolous? Because I won't know until I file them.
Well, the 2 attempts you've made to file documents previously were both deemed to be frivolous.
So should I just bring them to you directly and then you'll let me know?
I haven't made that ruling yet to require screening before filing, but it's on the horizon if you continue to file things that have nothing to do with the criminal case.
Bobby, you do not have to go through life like this. You can change. You can just watch The Godfather. It is excellent, excellent content.
Okay. So because you answered no to the first couple questions, you really aren't capable of representing yourself. And I do think that my ruling yesterday was correct. It seems that you're unable or unwilling to abide by the rules of procedure and substantive law, and I don't think that you can make a valid waiver of counsel. The court had spent some time yesterday afternoon reviewing a case, Hotep L v. State of Indiana. And of course, the citation didn't make it onto my notes here, but I can get that for you, Mr. Patton. Okay. And I think that's an adequate Feretta inquiry. Again, I think I must deny your request to proceed pro se. The court does not, well, I'll phrase it the opposite way. The court specifically finds the defendant's request is not a genuine attempt to present a legal defense, but a calculated strategy to
That is
obstruct
not
and
true.
subvert these proceedings.
The pirate movie
defendant
was excellent. Oh God, who was it? Christine McNichols. Excellent movie. You should watch it.
It's utilizing the rhetoric of what is commonly referred to as the sovereign citizen movement, including raising nonsensical challenges to subject matter jurisdiction and attempting to apply commercial law to a criminal prosecution. The right of self-representation is not a license to abuse the dignity of the courtroom or ignore relevant rules of procedure and substantive law. Based upon the filings that were previously stricken and the statements in open court today, court finds that the defendant's unwilling to comply with the rules of procedure and intends to use self-representation solely for the deliberate disruption of the proceedings. So I will deny the request to proceed pro se. I will maintain the appointment of counsel of Mr. Patton. And I think that will do it. We need to get some hearings. We need to get a hearing on the calendar.
I want to object to your ruling on the record.
So noted. Did you want to add anything to your objection?
I know I can represent myself.
You're going to be here on April 27th. I don't see that you have anything noted. We'll have you back, sir, on April 27th at 9 a.m. It's critical you get the name change information to us, so if that's correct, we can get your name updated in our court file.
Absolutely. Will I be released from jail?
You will be. Yeah. We're not on the record in the contempt proceeding. I think that was knitted up yesterday afternoon. I do have an order that is in drafting. I couldn't get to it yesterday because the access I had to my hard drive was cut off. But I will get the order finalized today.
All right.
I'm not even going to go on the
I can understand access to like a shared drive being cut off. How did the access to his hard drive get shut off?
record for that. So he'll be released, though. I think that it was a one-day term of sentence yesterday.
Can I speak one more thing?
Go ahead.
May I ask for screening on documents I want to add?
We can add in our,
I don't want to go behind your back to if you think it's wrong that what I was trying to do, I want to come with clean hands with this.
we can add in our order today that you're welcome to file things to your attorney. And then if he's satisfied that it's something that should be brought to the court, then he'll be able to present that to us. So when we appoint counsel, all the documents and things that would be filed with the court have to come through that attorney. And as I mentioned yesterday, you're not allowed to do what's called hybrid representation. So if you attempt to do things where you file outside of your counsel's purview, then that'll either be stricken from the record, or I will just do an entry reminding you you're not allowed to do hybrid filings and take no action on those requests. Anything, Mr. Patton? Okay. And we'll look for you back on April 27th at 9 a.m. We're adjourned.
Your Honor, if I would put this up on return to jail.
Absolutely. Yeah, thank you.
We'll look across I was going to say across the street. Slow.
Possibly.
Murphy's sitting out. He was here. I think they're both up there. No.
I didn't get to sample that yesterday, but I'm going to have it close today. I'll give you.
Where are you going? I didn't know we got a new pasta restaurant up on Calumet. Mama.
It just opened the other day.
Yeah.
I think you could probably boil up some spaghetti at your own house.
Yeah. I was going to say the concept seems a little weird, but
Restaurant sounds delicious.
Yeah. Thank you for your patience this morning, Mr. Murphy. Needed to get that gentleman on his way. I am overflowing with patience. State, please set a record for Daniel Nunez Portillo.
yes, this is State of Indiana versus Daniel Nunez Portillo, 64D01, 2311 F210756. Defendant is present with counsel attorney Murphy. State's represented by Deputy Prosecutor Hammer. We're set for sentencing.
Okay, State, anything on the pre-sentence report?
I guess in the probation's portion where they talk about evaluation and summary and aggravators and mitigators on page 9 of 10. I'm not sure why, I don't know if it was left off or what, but they had mentioned that he had violated twice for substance use during pretrial, which would then be an aggravating factor that I'm not sure.
Okay. So you'd like for me to add the aggravator of violations of pretrial release?
Yes.
Okay. Anything else, sir?
No.
All right. Mr. Murphy, anything on the pre-sentence report?
Just the same thing.
Can you get the microphone over by you?
Got it.
In regards to number 9, Judge, it says that he has a history of criminal and delinquent behavior. We don't believe that's a significant aggravating factor based on Edmonds versus State 840 Northeastern 2D 456, which basically says significance varies based on the gravity, nature, and number of prior offenses as they relate to the current offense. And the Edmonds case is largely similar to this case, where the history in Edmonds was a juvenile and then a disorderly conduct offense that occurred long before the current offense. And I believe his history here is some juvenile stuff, which obviously occurred very long time ago. And then the only other conviction was a driving offense. So we don't believe that a criminal history would be aggravating. We also don't believe that he was ever found to have violated his pretrial release either. We also believe that there's a number of mitigating factors. Obviously, a guilty plea is always a significant mitigating circumstance. Of course, we'll be arguing that in our argument to the court. That's always a significant mitigating factor. He also has children. It's noted in the pre-sentence report. He spends the summers with them. He does send financial support to them. He has a good relationship with them. We believe that any incarceration would cause undue hardship to his dependents. We believe that would be a statutory mitigating factor. Also, as I indicated earlier, his guilty plea is a mitigating factor.
Or it could build their character. Do you ever think about that? Maybe if he went to jail, they will become better people.
We believe that should have been listed. And of course, I'll be arguing that in my sentencing. Obviously, the court also takes into consideration the nature of the offense and the character of the offender. We think his character is a mitigating factor as well. Of course, I'll be arguing that.
Aren't you now? Anything else you want to bring up on the pre-sentence report?
No.
Okay. Evidence or argument for sentencing state?
Yes, Your Honor. I don't have any additional evidence.
Okay, before we do that, do you have any evidence?
I do. Did the court receive my character letters that I did file yesterday?
I did receive your character letters. I did not receive them in time to look at them because they just got docketed right now. Let me spend a moment to review them.
And then I also have one witness as well.
Okay. Let me review these first. I
Okay.
think it's important.
And Your Honor, state has not had a chance to review either. If I can,
Can you open them up? And
I'm going online right now to hopefully pull them up.
you should be able to find them. If not, let me know. I can print them off up
Okay.
here.
I have copies if you.
I think I can, as long as I can get the Odyssey, it should be fine.
Okay, I'll note for the record that I read the letter drafted by Reynaldo Portillo, the letter of Maria Urquiza, and Maribel. And Maribel didn't include her last name, and I can't read her signature, but I read her letter. How are you doing, State?
I'm almost done. I'm on the
Okay.
last one. Okay, Your Honor.
Okay. Your witness then, Mr. Murphy?
Yes, please. Thanks, Judge. I was
Sure.
running. Yes.
Okay. She'll be under oath then?
Yes.
Okay. Come on around here, ma'am.
It took me forever, V, to force my brain to think of JK as a man. It's still hard for me to say that out loud. My brain doesn't think it. It's just, it locked into a gender at the very beginning.
Please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth? Okay, thank you. You can be seated, please.
Thanks, Judge. Would you please state your name and spell it for the benefit of the court reporter?
Veronica Nunez, VeroNicaNunez.
And what is your relationship to Daniel?
I'm his sister.
All right. You guys reside together?
Yes.
And where's that at?
It's in Battle Creek, 92 Cedar Ave South.
And how long have you guys resided together?
It's been 2 years.
Okay, can you tell the court who's all here to support Daniel today?
My sister, my mom, my dad, and my brother's girlfriend and myself.
All right. Are you guys a close family?
Yes,
All right, does your brother work?
he does.
And where's he currently employed at?
Denso Manufacturing.
And how long has he been employed there?
I want to say about 2 years as well.
Okay, and you understand what your brother's charged with today, correct?
Yes,
Okay, and he's pled guilty and he accepts responsibility for what he's done.
yes,
Um, does Daniel have any children?
he does.
And how old are his children?
15, 14, and 13, I believe.
Does he send financial support to them?
Yes, he does.
Okay, and has his children been at your house?
Yes.
Okay, I believe he's currently going through a divorce. What's kind of the visitation situation?
From what I know, it's been during the summers that they would come over.
I believe the children are in Texas, correct?
Yes,
And you guys are in Michigan, correct?
yes,
So this last summer, they spent the entire summer at your home?
yes,
Okay. Does he talk to his children often?
yes.
How often would you say?
It's over the phone. So like I'm not always with him, but I do see where he'll message them and sometimes call them video call.
Are you married?
I'm not.
Do you have a significant other that lives with you or no?
No,
Okay, do you have any children?
I do.
And how old are your children?
9 and 5.
And does Daniel help out at your house?
Yes.
And can you tell the court how so?
He's actually the father figure for my daughters. He picks them up from school because I don't have anyone to pick them up. Since I'm a single mom,
And there's
he
no
does
bus.
basically take the role for their dad. My girls love him, and they did write a letter too. I'm not sure if it came in time, but they did say that they have seen a change in him because they didn't really spend time with him at first, but now that he's lived with us,
I met Linus. I did.
he's the dad that they don't have as a great dad. So they just, they would rather be with him than with their actual dad. And so he also, like, between 3 p.m. when they get off of school and 6 p.m. when I get off of work, he is their guardian at that time.
Does he provide financial support as well?
Yes.
Okay. Do you think he would respond affirmatively to probation or short-term incarceration?
Yes.
Do you think he has a problem with substance abuse?
Possibly, but he has been going to counseling, and my daughters do make sure that he also goes as well. So they do want to make sure that he does follow his work.
All right. And does he have strong family support?
Yes.
Okay. I don't think I have any other questions.
Okay, state.
Has he only been living with you since the filing of these charges?
Yes.
So prior to that, where was he living?
I don't know. I want to say at my mom's house.
Okay. And where is that?
We are super, super close. He is the center of my children's lives. No, I'm not sure where he was living though. I don't know.
On Cliff Street in Battle Creek.
Okay. And when did he begin these classes?
I want to say 2 or 3 weeks ago.
So just recently.
Yeah.
Okay. I have nothing further.
Okay, thank you. Any follow-up?
No, Judge.
Okay, thank you. Ma'am, you can step down. Chief, will you? Thank you. Further evidence, sir?
No other evidence, Judge.
Okay. Argument, State?
Yes, Your Honor. Just to kind of summarize, he's been arrested 3 times as a juvenile with 1 conviction for aggravated assault. And then as an adult, he's been at least arrested 3 times and arrested and or charged with a dangerous weapon as a felony, and then 1 conviction for driving while suspended, including the case that is here. There are substance abuse issues that are mentioned all throughout here, but it appears, at least my review of it, is it's trying to be used as an excuse for his behavior and otherwise down.
I don't think that they should be allowed to say how many times he's been arrested. They should just be allowed to say how many times he's been convicted. Seriously. Innocent to proven guilty.
Play the seriousness of what was going on here. Again, we also have 2 positive drug screens while on pretrial or on release for cocaine being in October and as recently as December of this year, which wasn't consistent with the statements that he's provided within the PSI where he says he's abstained from all of that, Your Honor. So with not being forthcoming with that information and those 2 positive drug screens, state does have some concern about his willingness to truly commit to any sort of programming or anything like that outside of the Department of Corrections. Furthermore, the quantity is in way excess of what should be required. It's only required that 10 grams be able to meet the threshold of the charge that is placed here. And this is 2.32 kilos of cocaine, which would indicate this is not a first time thing. Based on state's caseload and review of cases, you don't get the 2.32 kilos first time dealing or first time possessing or anything like that. That usually takes a significant amount to earn quote unquote trust from somebody to allow you to have that much cocaine or to bring that much cocaine around, Your Honor. There's a serious escalation in this behavior from his prior arrest. I mean, originally the aggravated assault and even only the arrest for a dangerous weapon as a felony provided some caution as an adult, but this is way above and beyond, Your Honor. You're, again, rocket launching because of the...
Rocket launching. No, Bren. No. That's not why they think you're nuts. You should keep digging.
2.32 kilos, again, is a significant, serious escalation in the behavior and the potential danger it provides to the community and to others, and even himself in this instance. Because at least with possessing that amount,
What? 5 pounds of coke? Is that what they just said? That's crazy. I didn't even realize.
Your Honor, this isn't like Costco. You're not getting 2.32 kilos for personal use. There's a significant use by others and danger to others as it comes to this, Your Honor.
Wait, okay. Now we have to jump from Godfather to Scarface. Because, sir, have you seen Scarface? Because that was personal use.
Was listed as a moderate risk to reoffend throughout this. And again, understanding his family situation and all that, state understands that he is only providing financial to his actual family with the kids that are down in Texas. So visitation and all of that, it's just purely financial, Your Honor. So it's not unduly, incarceration wouldn't be unduly or unfairly, I apologize, Your Honor. I'm losing my words this morning. Unfairly burdensome on the family. It is burdensome, but not unfairly burdensome. With what is going on here, Your Honor, and given all of that, and also with what is contained within the PSI for the further part of the risk assessment and all of that, Your Honor, understanding what's going on, the state would be suggesting an 11-year DOC sentence with 7 years executed with 4 on formal probation, which could be transferable, and state would be open to the RWI program. However, would suggest that the court place a floor on any potential modification after that program. State's suggestion would be he do at least 3.5 years executed, so half of his sentence before he be able to petition for any modification, Your Honor. And any substance abuse that goes along with it, because again, throughout the PSI, it's riddled with substance abuse issues, Your Honor.
Thank you, counsel. Mr. Murphy?
Thanks. As the court's well aware, I mean, the two main factors in sentencing is the nature of the offense and the character of the offender. There's also statutory aggravating factors, statutory mitigating factors. He did plead guilty to a level 3 felony. There is a cap of 11.
Okay, I just asked Google how much 5.07 pounds of cocaine is worth. $81,120. However, that could fluctuate a bit.
Years. So the court's sentencing discretion is between 3 years to 11 years. Basically, on his character, Judge, he has limited criminal history, as noted in the pre-sentence investigation report. His last offense was driving while suspended in 2010, which is more than 13 years ago. I mean, no criminal history for 13 years. He has no prior substance abuse offense before this one. Basically, as I stated earlier, based on the Edmonds case, deciding whether criminal history is, you have to look to see if it's significant. These prior offenses are not similar in nature. The only conviction as an adult was a driving while suspended. Absolutely no significance at all. We believe here that the defendant pled guilty. He accepts responsibility. A guilty plea is normally considered a significant mitigating factor. I mean, sometimes it's not given much weight sometimes when there's a situation where the guilty plea was pragmatic. I mean, this was a drug case. The court's obviously familiar. I mean, most cases that do go to trial in a criminal context are constructive cases. I mean, obviously, you have actual possession where drugs are on somebody. Constructive is when they're not on someone. In this particular case, defendant was in a vehicle with another person. Substance was not on him. I mean, this was a case of a constructive possession, but my client did take responsibility. He did admit that, he said in the PSI the drugs were his, but I mean, this is a case, obviously he would have the right, he could have remained silent and put the state to the test and made the state go through a trial, which he did not do. So I think the fact that he pled guilty should be given significant weight as a mitigating factor. As indicated earlier, he has children. He sees, he's kind of just recently split with his wife. They're going through divorce proceedings. She lives in Texas. He lives in Michigan. He did see the children in the summer. He has regular contact with them. He does send them
that sounds like a great marriage. Why are they going through a divorce? That sounds perfect.
Financial support. Also, you heard from his sister who testified that she has two young children too that are dependent upon him as well. I think that, significant, I mean, any kind of significant incarceration could cause an undue hardship on those dependents, even though they're not his children. It would affect them. It would also affect the other children. His family's close. He's got strong family support. They're all here. Based on his criminal history, he hasn't really ever faced any significant time. This is the first time that he has been in significant, this is a drug case. The court sees defendants come in front of the court all the time for drug and alcohol problems. I mean, most of the time people don't just wake up one day and decide they're going to go for help. Unfortunately, most people who have a drug or alcohol problem are in denial. You've kind of read the letters. I mean, a lot of times drug and alcohol use is used as a coping mechanism. And as the court can see from the letters written, he grew up,
He's not a user, sir. He's a seller, sir. Sir, he's not using it to cope.
His mother supported him, had a lot of time, ended up dropping out of school, started working right away, ended up getting married, having some children, working a lot, and alcohol.
Me and Nan can tell you, you can purchase yarn as a coping mechanism, and that is way better than drugs, guys.
Alcohol and drugs was more or less a coping mechanism. for a long period of time that he was in denial about. You know, this has been a big wake-up call. I mean, obviously, he's facing significant time, you know, based on all those factors. And, you know, I think he'll also want to address the court. You know, I think he's very remorseful for what he did here. We think, you know, we're asking the court in regards to sentencing, we think that the mitigating factors outweigh the aggravating factors. I mean, the starting point is 9 years. We're asking the court to sentence him to 7 years. We're asking the court to consider suspending the entire sentence to probation and allow him, as a condition of probation, to do some kind of court-approved program. He would be under the thumb of the court for obviously a long period of time. And if he violated, he obviously would know that he would be going to the Department of Corrections. If the court were inclined to give him any time, we believe that the court, you know, if it did sentence him to some time at the Department of Corrections, that the court would make the recommendation that he be in recovery while incarcerated, and put in the sentencing order something along the lines that he would be able, upon completion of that
Do
program.
they have a sir?
Petition the court for modification. Thanks, Judge.
Okay, thank you, Mr. Murphy. Mr. Nunez-Portillo, this is your chance to say whatever you might like to say before I rule on the case. Would you like to exercise that right, sir?
Yes, sir.
What we would like to hear from you, sir, is how you understand how you are destroying children, you are destroying families, you are ruining people's lives. Just tell us about that. Let's see, guys. Let's see if he does.
Thank you.
All right. I'm not real good at public speaking. I had to write a letter, but it's
Sir, take your time.
I understand that my actions have brought me here today. I would like to apologize to my family for putting them in the situation as well. I do take full responsibility for my actions, and I would like to say that I am trying my hardest to become a better man, especially for my mom. She had to come here from across the states, even though her health is not the best at the moment. I have taken the first steps to sign up for Narcotics Anonymous recovery meetings. With the full support of my family, I would like to soon leave this whole situation behind me, succeed in my recovery, and start a brand new life. I'll do whatever classes I have to do. I'm over with this part of my life.
What was that last part, sir?
I'm over with this part of my life.
Except for the people that you sold those drugs to, it's not over for them. They're addicted. They're still dealing with it. They're still trashing their entire life and their family's lives. But how many times did he say, I, my there? All of it. All of it was just I, my.
I just want to be sober and start fresh.
Okay, sir. Thank you for your allocution. I don't know if I entered judgment of conviction or not yet.
Okay, if I remember correctly, prosecution wants 9 years jail. And then defense wants 7 years probation. All right, Judge, what are you going to do?
All right. Well, at this time, the court will accept the recommendation of plea negotiation. Pursuant to that, enter judgment of conviction on count 2, possession of cocaine, 28 grams or more, a level 3 felony. When we sentence, we start with the advisory sentence and we work up or down in years from there, depending upon aggravating and mitigating circumstances. And although the state suggests there were violations of pretrial release, I don't have any of that in the doc.
I'm going to guess 4 years jail, 4 years probation. That's what I'm going with.
Okay. To indicate that there was a violation of pretrial release. At least there was never anything filed by the pretrial services office in my quick scroll through the record. So I'm unwilling to adopt that. I do note that there's a history of criminal or delinquent behavior, and I agree with Mr. Murphy. I'm allowed to assign weight to that based upon its significance. And it's been a long time. I also appreciate pre-sentence report writer's indication, and I think that the state picked up on those words, that this appears to be a significant uptick in misconduct or use of drugs since he had led a relatively law-abiding life. So I will adopt that aggravator. I've been asked to adopt a mitigator from the defense related to the guilty plea. But that one, again, I have the ability to assign some weight. Here, there was a level 2 felony case dismissed, and he received a significant benefit of his bargain. 2.3 kilograms of cocaine is much more than one would anticipate someone maintaining for personal use. So the court's opinion is that the assertion here from Mr. Nunez Portillo in the pre-sentence report and through counsel is a disingenuous one related to
You mean he
the
lied?
effect of the guilty plea as accepting his misconduct. Definitely he accepted the level 3, but it seems here the conduct was more along the lines of the level 2. So to get the full benefit of that mitigator, one would have had to have submitted themselves fully. I agree with the state, the children, and the impact or hardship upon the dependents is present, but not particularly significant. And I do agree with Mr. Murphy, and I will adopt the mitigating factor that the character of the defendant is one of a typically law-abiding citizen who now has become a little bit involved with problematic drug use and a substance use disorder. Because the court finds that there's a balance between the aggravator and the mitigating factors in this case, the sentence based upon the advisory number of years is appropriate, and that's well within our cap. So I will sentence you, Mr. Nunez Portillo, to 9 years in the Indiana Department of Correction. That sentence will be executed. I will sentence you into the recovery while incarcerated program. Decline to order any probation at this time, but after 3 years of time served, I will consider any modification that is filed. You do get credit for your time served awaiting disposition of the case. It appears that credit time is from November 25th of 2023 to December 7th of 2023, Class B credit to be applied. You will be ordered into the recovery while incarcerated program. I will not consider a modification until you've served 3 years, and you'll have to pay the drug abuse prosecution, interdiction, and correction fee of $200. There was a pretrial services balance of $275 on the case. There does appear to be a cash bond posted in the matter. From the cash bond, the court will retain court cost, the jail booking and sheriff's death benefit fee, that $275 remainder. Do you have an assignment, sir? Have you filed it? Okay, you should probably bring it up. I don't see it here. Correct. Thank you.
Yo, I wish they'd treat my ex-husband with some mushrooms.
Looks like Jose Nunez posted this. This would have to be countersigned by Jose Nunez for it to be valid. Mr. Daniel Nunez Portillo is not competent to assign the bond proceeds when it's posted by Jose. So I can keep this one with the understanding that you'll file an updated one with a proper counter signature within 10 days. Okay, is Jose easily available to you?
Oh, fine. I'll get some contact.
Looks like he's in Battle Creek, Michigan. Would you prefer to have 3 weeks?
Yes.
Let's go to 21 days to be safe. Allow counsel to get an updated bond assignment to me within that period of time.
Monica, I'll move with you.
Do you understand your sentence, Mr. Nunez Portillo?
Yes, sir.
Okay. You have a right to appeal the sentence imposed herein. In order to do so, you must file either a notice of appeal or a motion to correct errors within 30 days of today's date. If you elect to file a motion to correct error, you must file your notice of appeal within 30 days of an adverse ruling on that motion. Failure to comply with these requirements will result in the forfeiture of your right to appeal. You have a right to counsel at all stages of these proceedings, including this appeal, if you choose to take one. If you're unable to afford a lawyer, I'm obligated to appoint one to represent you at no cost. Do you plan to take an appeal, sir?
No, sir.
Okay, if that changes and if you're in court, or I'm sorry, if you're in jail within the next 30 days and you decide something different, write a letter to the court.
I wonder if you get free health care in Australia if you're just like visiting for like a couple months. Like you go there for a couple months. I'm sure if you break your leg, then you can see a doctor there, I'm sure. But what about other things? Like a dermatologist or, you know, an eye doctor or something. I wonder if you get free health care if you just are visiting.
With that request and whatever other request you might make, and we will handle it accordingly, okay? But at this time, I'll decline to appoint
not
counsel
Jethro.
for you. I would ask that our security staff, I'm remanding Mr. Nunez Portillo to the custody of the Porter County Sheriff, pending his transport to the Indiana Department of Corrections.
No, I don't.
Did I miss some?
Yeah, it's fine.
And I'm dismissing
Fine.
count one. Yeah, which I did not say out loud, but I'll say it now. We're adjourned.
So it's possible he only gets 3 years. He got 9 years executed, but you know, the judge is going to look at it in 3 years. I can stream from anywhere in the world. Anywhere. I'm streaming from Lancaster, Pennsylvania, where half of us don't have electricity because we're Amish. I'm not Amish. I would be a very bad Amish. I would really get excommunicated. What is that called? Shunned, but isn't there a word? Shunned, excommunicated, but there's a word, isn't there? When you get kicked out of the Amish, there is a word. I just can't remember what it is right now. It's gonna come to me as soon as the stream ends, though. All right, this is the next day. Honest to God, I have no idea if anything happens. We're just watching it because I needed more content for today. Okay, Mr. Shargaloff is here.
Morning, Joe. Can you hear me?
And beautiful inmates are here. This will be good.
What's that? All right. Morning, State.
For Jerice Johnson, Your Honor. State of Indiana versus Jerice Johnson. The cause number is 64D01 2604 F63568. Defendant is present in court in person by video conferencing. She is here with Mr. Ken Elwood of the Public Defender's Office for Criminal Rule 2.6 purposes. State of Indiana by Gary Gerwin.
Morning, ma'am. Would you state your name for the record? Would you raise your right hand and be sworn, please?
Yes.
Do you promise, swear, or affirm under the pains and penalties for perjury that the testimony you will give the court will be the truth and nothing but the truth?
Yes, sir.
Put your hand down. Would you state your name, please?
Gary.
Oh my gosh, guys, look what we got. Are you watching this? What's happening? It just hit me. Mr. Shargaloff is the judge today. I don't know where Judge Fish went. Maybe yesterday he had that Sov Cit and he needed a day off. He's like, that's it. I need a break. So Mr. Shargaloff is the judge. You go. You need some robes on you, sir.
Ms. Johnson,
And Ms. Johnson, your date of birth.
2/15/84.
Are you currently under the influence of drugs or alcohol?
No, sir.
Have you ever been diagnosed with any mental or emotional disability that would impact your ability to understand what's going on here today?
No, sir.
Do you read and understand the English language?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Ms. Johnson, I have to advise you of the constitutional rights that apply in a criminal case. You have the right to have an attorney represent you. You have the right to have an attorney appointed to represent you if you cannot afford an attorney. You have the right to a speedy and public trial by jury. You have the right against self-incrimination, meaning you cannot be forced to make any statement or to testify against yourself at any hearing or trial held in this matter. Do you understand the constitutional rights that apply in your case?
Yes, Your Honor.
Mr. Grimman, would you read the charges, please?
Yes, Your Honor, thank you.
I have huge issues with their community. Huge, humongous. That's one of them.
Count 1 alleges theft, a level 6 felony. It's alleged that on or about the 31st day of March 2026 in Porter County, Indiana, the defendant did knowingly or intentionally exert unauthorized control over the motor vehicle of Jamie Williams with the intent to deprive Jamie
Grand
Williams
Theft
of the
Auto.
vehicle's value or use or a component part of the vehicle. A level 6 felony carries anywhere from 6 months up to 2.5 years in the Indiana Department of Corrections and up to a $10,000 fine. Count 2 alleges unauthorized entry of a motor vehicle, Class B misdemeanor. It's alleged on the same date, March 31st, 2026, in Porter County, Indiana, the defendant did knowingly or intentionally enter the motor vehicle of the owner, Jamie Williams, knowing that she did not have the permission of the owner, lessee, or authorized operator of the motor vehicle to enter the motor vehicle and did not have a contractual interest in the motor vehicle. It's a Class B misdemeanor that carries anywhere from 180 days in the Porter County Jail and up to a $1,000 fine.
Ms. Johnson, you may not agree with the charges, but did you hear and understand them?
Yes, Your Honor.
Did you also hear the possible penalties?
Yes, Your Honor.
Pursuant to statute, we will enter a plea of not guilty on your behalf. Set the following
He's
dates
doing good
in
so
your
far.
case. Ms. Johnson, do you plan to hire an attorney?
I cannot afford one, Your Honor.
I have to ask you some additional questions in follow-up of that. Are you currently employed?
No, Your Honor.
Do you have any bank accounts or any assets of monetary value?
I have a bank account that has $22 in it currently, Your Honor.
She's got
You own a
double
vehicle?
me.
No, I don't, Your Honor.
Do you have any interest in savings accounts, stocks, bonds, anything like that?
No, Your Honor.
The court will find that you are indigent. Appoint Attorney Steve Pribble to represent you in this matter. Set this case for the following dates.
I wonder if he's going to appoint himself for one of these girls.
May 29th, 2026 at 9:00 a.m. Did you hear that date and time?
Yes, Your Honor.
And a pretrial conference on July 10th, 2026 at 9:00 a.m. Did you hear that date and time as well?
Yes, Your Honor.
Ms. Johnson, you understand that you're ordered to appear on both of those court dates. If you fail to appear, a warrant may be issued for your arrest.
Yes, Your Honor.
For purposes of a bail determination,
Listen, for your retirement fund, you just need to go get 5 pounds of cocaine. You got this. I have faith in you.
Attorney Ken Elwood is here today as it relates to the issue of bond. Gentlemen?
Thank you, Judge. She scores a 4 moderate. I assume that's a little bit higher than would normally be because she's homeless. No FTAs, no current holds. Recommendation is OR release supervision level 1. I'd ask the court to follow that.
Mr. Grimmer, on behalf of the state.
Thank you, Your Honor. My only concern is that she's homeless and does not have a place to live, apparently. I have no objection to her OR release, but she does have to appear in court. She has a minimal prior criminal history, Your Honor. But again, I have no objection to her OR release, and I do not see any reason for her to be placed on pretrial supervision.
Very cool, Tona.
Ms. Johnson, are you able to make it back and forth for court?
Yes, Your Honor. After I leave here, I have a friend of mine in Cedar Lake who said I can stay with him until I get on my feet, Your Honor.
Any chance you have an
Bobby, you live in Cedar Lake, don't you? Don't you, Bobby?
address out there?
I do, but the police officers have it in my belongings.
Okay. All right. Based on that, the court's satisfied that you will appear for court based on the IRAS report that's been filed. Court will release you on your own recognizance, or do you do appear on the dates previously provided to you? You understand that?
Yes, Your Honor.
Said anything else?
No, Your Honor, thank you.
Mr. Elwood, anything else?
No, Judge. Thank you.
All right. Thank you, Ms. Johnson.
Thank you so much, Your Honor. I appreciate it.
Yeah, happy Easter. Thanks, Ken. Seth Morales, Your Honor.
Yes.
Seth
Mr. Lawson?
Seth Lawson, excuse me. This is State of Indiana versus Seth Morales Lawson. The cause number is 64D01-2407CM7092. Defendant appears in court in person by video conferencing without counsel. State of Indiana by Gary Gurman.
Sir, would you raise your right hand and be sworn, please?
Hi, Crystal.
Do you promise, swear, or affirm under the pains and penalties
That's
for perjury
pretty cool,
that the testimony you will give
Sandra.
the court will be the truth and nothing but the truth?
Yes, sir.
You put your hand down. Would you state your name, please?
Seth Lawson,
And Mr. Lawson, your date of birth?
April 2nd, 2003.
Are you currently under the influence of drugs or alcohol?
No,
Have you ever been diagnosed with any mental or emotional disability that would impact your ability to understand what's going on here today?
no, sir.
Do you read and understand the English language?
Yes, sir.
Are you a U.S. citizen?
Yes,
Just for purposes of the record, I have represented you in the past. Do you waive any conflict that could be present as a result of me hearing this case today, sitting as Judge Pro Tem?
yes,
Mr. Gurman states position.
No objection, Your Honor.
So Mr. Lawson, along with Courtney White and Casey Usaloglu, please pay attention. The following are the constitutional rights that apply in a petition for revocation of probation. If it is found that you violated your probation, in a revocation proceeding, you are entitled to a hearing where you have the opportunity to be heard and to present evidence. The state would have to prove that you violated the terms of your probation by a preponderance of the evidence. You have the right to counsel. If you cannot afford counsel, one will be appointed for you by the court if you qualify. You have the right to compulsory process, meaning the court could issue subpoenas to bring witnesses into court to testify on your behalf. You have the right to remain silent. You have the right to a hearing, not a trial, again, where the state would have to prove that you violated your probation by a preponderance of the evidence. If it is found that you violated your probation, any part or all of your previously suspended sentence could be imposed as jail time. Additional conditions could be added to your probation or an additional length of time added to your probation. Any or all of those may occur if it is found that you violated your probation. Do you understand the possible penalties for a probation revocation?
yes, sir.
Petition for revocation of probation was filed on March 24th, 2026. Officer York alleges that you violated Rule 2, employment, that as of the date of the petition, the defendant has failed to provide the officer with proof of employment or enrollment in GED classes. Violation of Rule number 4, financial obligations, alleges that you were in arrears $120 in probation user fees through March 2026. Rule number 8, it is alleged that on March 20th, 2026, you were found to be under the influence of intoxicants when you scored a .154 on a portable breath test administered by the Indiana Department of Natural Resources. And finally, rule number 11, that on March 20th, 2026, you engaged in criminal conduct when you were arrested and charged by the Indiana Department of Natural Resources with 2 counts of operating while intoxicated as a Class A misdemeanor under cause number 64D042603 CM3160. 15-day hold was placed on you on March 23rd, 2026. Mr. Lawson, you may not agree with the allegations, but did you understand them?
Yes, sir.
And do you wish to admit or deny the allegations?
Deny.
Show denial entered. Do you plan to hire counsel?
I haven't working, so no.
Are you asking that the court appoint a public defender to represent you in this case?
Yes, sir.
All right, I have to ask you some additional questions. You've already testified that you are not currently employed, correct?
Yes, sir.
Do you have any bank accounts?
No,
Do you have any vehicles that you own?
I do.
How much is that vehicle worth?
2000. I paid 2000 for it at 22.
Do you have the ability to sell that vehicle?
No, it's been broke down since.
Do you have any other assets, stocks, bonds, anything else of value?
No, sir.
Court will find that you are indigent. Appoint Attorney Steve Pribble to represent you in this matter. Set this case for a status hearing on April 17th, 2026 at 9:00 a.m. Mr. Lawson, you understand your order to appear here then? You have to answer out loud, sir.
Yes, sir.
And as it relates to bail, Mr. Gurman?
Yes, thank you, Your Honor. And after reading the recommendation of the probation officer, I'm recommending that he be held without bond and that he be given an opportunity to enroll in the next chemical dependency program at the Porter County Jail, which should begin in about 2 weeks.
Mr. Lawson, anything that you would like to say on your behalf regarding the issue of bail?
Yeah, I've been going to school. She told me on April 6th to come in with my report from my school. So that was the plan, and to pay my fees the next time I seen her, which was supposed to be on the 6th. So she told me to bring a progress report from my school. I started school on the 6th. So I've been trying to get back out to school. And I have the money. I can get the money from my parents to pay the fees.
He's going to college for personal trainer.
At this point in time, Mr. Lawson, I am not comfortable making a decision because I had previously represented you. I hear what you're saying and I understand what the court is saying as well. I'm going to set this for a bail review hearing next week, Friday. Is there room? We'll set you for next week, Friday, which is April 10th, 2026 at 9:00 a.m. Attorney Pribble will argue the issue of bail and Judge Fish will be back that day. Have you ever worked with attorney Jesse Harper?
No.
Okay, Attorney Harper will be sitting as Judge Pro Tem that day. I would feel more comfortable with him making that decision regarding the issue of bail, Mr. Lawson. Thank you, sir.
Or Courtney White, Your Honor. State of Indiana versus Courtney White. The cause number is 64D012505F65468. Defendant appears in court in person by video conferencing. She's here with counsel, Mr. Steve Pribble, also by video conferencing. State of Indiana by Gary Gurman.
Morning, ma'am. Would you raise your right hand and be sworn, please? Do you promise, swear, or affirm under the pains and penalties for perjury that the testimony you will give the court will be the truth and nothing but the truth?
So help me, yes.
Pardon me?
Yes, sir.
You can put your hand down, and could you scoot a little bit closer and speak up a little bit so we can hear you? Would you state your name for the record, please?
Courtney White,
And Ms. White, your date of birth.
May 1st, 1989.
Are you currently under the influence of drugs or alcohol?
No, sir.
Have you ever been diagnosed with any mental or emotional disability that would impact your ability to understand what's going on here today?
No, sir.
Do you read and understand the English language?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Were you present in court earlier when I read the constitutional rights that apply in a petition for revocation of probation?
Yes, Your Honor.
Did you hear and understand those rights?
Yes, sir.
Do you have any questions about those rights?
No, sir.
Mr. Pribble, have you had the opportunity to review the allegations with Ms. White?
No, Your Honor, I haven't, but I have reviewed them myself.
Okay. Ms. White, it's alleged that on February 25th, 2026, the probation department filed a second addendum to the petition for revocation of probation. It alleges a violation of Rule 9 in that you tested positive for an illegal substance for a drug screen taken on February 22nd, 2026. The alleged drug was amphetamine and THC. Mr. Pribble, as to those allegations?
Deny, Your Honor.
Show denial entered. And how would you like to proceed today, Mr. Pribble?
Your Honor, I would just like to address the issue of her continued incarceration and bond at this point.
All right. State.
Yes, thank you, Your Honor. I'm happy to address that. I believe the last time
Thank you for the
Ms. White was
cheers,
supposed
Monica.
to
Thank
appear in
you.
court, but she appeared by video conferencing. She indicated that she was going to enter a treatment program called the Center for Recovery. She in fact did that on March 6th. However, according to the probation office, against medical advice prior to completing treatment on March 12th, she left that treatment. Given that this is the second addendum to the original revocation of probation petition, I'm asking that she be held without bond and given an opportunity to enter the chemical dependency program at the Porter County Jail.
Thank you, Mr. Pribble.
Your Honor, I think giving Ms. White the opportunity to attend or reattend an inpatient program is going to be more beneficial than having her incarcerated. So for that reason, I would just ask that the court release her on any previously posted bond so she can finish her program that she started. If the court doesn't do that, Your Honor, I do agree that assuming that Ms. White agrees, I would support the CDA program as well.
Mr. Pribble, do we have any documentation that she is eligible and or can be released to that facility?
Your Honor, I do not.
You know, if Judge Fish's day off would have been one day different, Mr. Shargaloff would have gotten the Sov Cit.
Attempted to contact them when I heard about this hearing, and I have not received a return call back, so I don't have anything I can present to the court at this time.
All right. Given that information and what the state has provided by way of summary from the probation department, the court is not inclined to release Ms. White at this time. Certainly that issue can be readdressed if the court is presented with some type of documentation that she has been accepted, to an inpatient treatment facility. But without that, at this time, the court will just affirm did I already set status? I'm sorry. Set this matter for status hearing April 17th, 2026 at 9:00 a.m. Ms. White, did you hear that date and time?
I did, sir.
You understand your order to appear on that date?
Yes, sir.
All right. The court will also order that you be placed into the chemical dependency and addiction program at the Porter County Jail at the next available spot. Anything else, State?
No, Your Honor. Thank you.
Thank you. Mr. Pribble, anything else?
No, Your Honor, thank you.
Thank you.
For Casey Yusalagu, State of Indiana versus Casey Yusalagu, cause number is 60.
I think he's doing a really good job, but he really hasn't had a tough case yet. We need someone to resist a little bit.
4D01-2203F62609. Defendant appears in court in person by video conferencing. She is here with counsel, Mr. Steve Pribble, also by video conferencing. State of Indiana by Gary Gurman.
Ma'am, would you raise your right hand and be sworn, please? Do you promise, swear, or affirm under the pains and penalties for perjury that the testimony you will give the court will be the truth and nothing but the truth?
Yes, Your Honor.
Put your hand down. Would you state your name, please?
Casey Usalawu,
And ma'am, your date of birth?
10/3/89.
Are you currently under the influence of drugs or alcohol?
No, sir.
Have you ever been diagnosed with any mental or emotional disability that
Robert, you missed day 2 of the Sov Cit. It's at the beginning.
would impact your ability to understand what's going on here today?
No, sir.
Do you read and understand the English language?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Were you present in court earlier when I read the constitutional rights that apply in a petition for revocation of probation?
I was, Your Honor.
Did you hear and understand those rights?
Yes, Your Honor.
Do you have any questions about those rights?
No, Your Honor.
Mr. Pribble, we are here for an admit deny. Have you had the opportunity to review the allegations contained in the petition for revocation of probation?
No, Your Honor.
All right. Ma'am, it is alleged by the probation department with a petition filed on January 13th, 2026, that you violated Rule 1, reports. You paid her $500 cash bond, were released from the Porter County Jail on January 1st, 2026.
Micah, did you get your blood results back yet? Are you doing okay?
In order to report to probation by telephone, and you failed to make contact with the probation department as of January 12th, 2026. The officer alleges she attempted to contact you, but the department does not have an accurate phone number for you. Your whereabouts were unknown at that time. You may not agree with those allegations, but did you understand them?
Yes, Your Honor.
Mr. Pribble?
Your Honor, I would just again like to address the issue of release and bond.
Enter denial on behalf of the defendant?
Yes, I'm sorry, Your Honor, absolutely.
Not a problem. Show denial entered on behalf of the defendant in this case. Mr. Gurman, as it relates to the issue of her release.
Yes, thank you, Your Honor. My notes indicate that there was a bench warrant issued for failure to comply back on January 5th, 2024. The defendant did not appear in court again until December 31st, 2025, almost a couple years later.
Yeah, she's not
She
getting out.
disappeared somewhere in the state of Illinois. When she appeared on December 31st, 2025, the court set bond in the amount of $500 cash, which she posted. On January 1st, she was ordered to report to probation, and she did not. She has absconded from this court's jurisdiction twice now. In fact, she failed to appear on January 16th, 2026, so another warrant was issued for her arrest for failure to appear. It is now April. I'm asking her that she be held without bond.
Mr. Pribble?
Your Honor, I think if Ms. Uzilago can establish residency here with the court, let us know where she's going to be, provide us with contact information. I'm sure she'll make herself available for all future hearings if that is a condition of her being released.
Why? Sir, you're her attorney. You should have said something a little bit more than that. Why did she abscond? I mean, at least lie about a dog or something.
All due respect, Mr. Pribble, I'm having a hard time believing that based on the chronology that's been established by the state. Unless we have something, quite frankly, I did not see the age of the initial cause number. And it's worrisome that we basically went through the entirety of 24 without seeing the defendant. So, ma'am, I'm going to ask you, where will you be living?
So, Your Honor, I will be living, I do have residency now in Joliet, Illinois, and I just had a baby on December 16th, so it's for sure residency. I am taking classes for parenting and substance abuse. And I can give you an address and a phone number if you'd like, sir.
And is that phone working?
It doesn't sound like she has the baby, right? Because she said, I had a baby in December or whatever, and I'm taking parenting classes.
Yes, the phone numbers are now, yes, I have valid numbers as well, yes. I did not currently, and I do apologize for that, sir.
Say that again?
I did not, I'm sorry, presently, before this, I did not, and I do apologize for that. I didn't give a correct number, but I do have a proper number now.
What date did you have your child?
December 16th, is that correct?
State, given that information, anything else?
No, Judge, my recommendation remains the same. She was scheduled to be released from probation September 6, 2024, and the only reason she wasn't is because of her actions. Otherwise, this would have been over almost 2 years ago.
I'm not changing
Ma'am, as much as I want to sympathize with the fact that you have had a child and are now engaging in services, that's just too long. It's too long for me to reasonably believe that you would appear back in court with placing you on probation. What I will do is set this matter. I am not going to order you released at this point or release you on your previously posted bail. I'm going to order that you be held at the Porter County Jail, reset this matter for status on April 17th, 2026 at 9:00 a.m. Hopefully, Mr. Pribble
This
and
was
the
April
state
2nd.
can work something out in this
That's when
case.
this day was.
But I will find, based on the information that's been provided, that you are in fact a flight risk at this point in time. Anything else, State?
No, Your Honor, thank you.
Anything else, Mr. Pribble?
No, Your Honor, thank you.
Thank you.
No bond.
Thank you, Your Honor.
Thank you, Joe.
All right, guys. We did it. We made it to the end. Mr. Shargaloff, you did a great job, sir. Thank you for coming out, guys. I appreciate it. I do. Today is Thursday, I think. Yep. So I'll see you tomorrow morning, bright-eyed and bushy-tailed. Again. Hey, guys, okay? I'll see you again soon. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in